All right, welcome everybody. This is the start of something new that I'm trying out. I'm going to be going over some cases. If you're not familiar with what cases are, we're talking about legal cases that have occurred in the past. These cases are the exact same cases you would see in law school. If you got accepted to law school, congratulations. Welcome to the legal industry. If you applied for law school and you didn't get in, there's next year, of course. And this will be a good introduction to what law school would be like. If you've never applied to law school and you're not really all that interested, I totally get it. It's a long, arduous path, it's expensive, and frankly, it is a very difficult industry. That said, in the United States, our government expects us to act as if we know enough about law to function and stay out of trouble. So you have to know some law, and you have to know how law functions to be able to function as a society. To function as a functioning member of society. This channel is going to be a little different from what you would see in other places, from the sense that it's not really going to be all that filtered. Most channels are very polished. They are built with a preset method that they have in mind. But learning is not perfect from the beginning. It starts out with an empty slate and you build as you go. So this is going to be just like that. If we haven't met already, my name is Ruben. I studied law at Pepperdine Law, and I am an attorney in California. Now, just because I'm an attorney and just because we are going over some of this material does not mean that I am your attorney. If you have an issue that you need help with, you need to reach out to an attorney. In most cases, a consultation will be free, so it is always good to talk to an expert regarding your particular situation. That in mind, the purpose of this channel is to be educational and to be entertaining. Or at least I'll try to make some of these things entertaining, as some of the material can be pretty dry. That said, this is a good time for me to give you a trigger warning as well. We see some pretty dark stuff in the legal industry. Most of the cases that you see here aren't going to be too crazy, but they can be pretty disturbing. So this is a good time to give you a trigger warning. You may see some things, so prepare yourself for that. I guess I should start by talking about what makes learning law different from other industries. Law school is built on the Socratic method, which is built after its original founder, Socrates. Now, Socrates wasn't really so much a fan of note-taking, nor was he a fan of structured education. He was basically a chaotic teacher. You go as you build as you go. You ask questions, and you have to be able to ask questions that are not always appropriate and that are not always clean. The Socratic method starts by humbling yourself. It's like Socrates said, the greatest wisdom is in knowing that you know nothing. So we have to begin there, and we have to be willing to ask questions. That is part of the reason why this channel is going to be so different from what you would see in other channels that talk about, that discuss law. Because most of them are already pre-sanitized with an answer. This is not going to be that. This is about discovering how to discover the answer. In a sense, it is about learning how to learn to read law and learning how to learn. Not about learning the content itself. The disadvantage to that, of course, is that it's not going to be easy. It's going to be kind of uncomfortable in the sense that you may watch some of these videos and think to yourself, okay, but what's the answer? Like, bro, can you just give me the answer? And the answer is, there is no answer. The answer is that it's a process that is built one on top of another. And that is the way that law is built too. It starts out with one case, and then another one comes along and it makes a little change. And then a second one comes along, or rather a third, and then it makes a little change to the first and the second. And that is part of the reason why you need an attorney to handle sensitive matters, because it changes every day. What could have been the answer yesterday might not be the answer tomorrow, or even today. Now, if you're watching this and you're thinking to yourself, yeah, but I don't want to be a lawyer, or I'm not interested in going to law school, or that's not in the cards for me, you still have to remember that no matter what, you're expected to know these things because the law will still hold you responsible, whether that's in a criminal sense or in a civil sense. The other big thing is, if you have some sort of basis of legal education, if you have a foundation, it makes it infinitely easier for you to communicate with an attorney should you ever need one, or rather, when you need one. It's not one of those ifs matters. And on top of it, it makes it easier to recognize, okay, this is something that I really need a lawyer for right now. And without that sort of foundational knowledge, you might not even recognize that your particular circumstance is one that really you should have a lawyer for. With that said, we're going to go ahead and get started. It's time to lawyer up. So, first case that you will see is Vosberg versus Putney. All right. So law school was divided, at least the first year, is divided into 6 main subjects. There's torts, which is essentially civil lawsuits, people suing each other for things that they did against each other. There is criminal law, which is when the government is suing people for crimes, and that usually translates to either a criminal fine or jail time. There is constitutional law, or constructure, as it's often referred to, which is essentially the functioning of government and what the limitations of government are, what they're allowed to do and what they're not. It's about rights, not individual rights like freedom of speech, but rather what kinds of things a government is allowed to do. There is contract law, which is agreements between people, which is different from tort law. And I suppose this is a good time to mention that tort law is, I believe, a French word, which means a wrongdoing. So that'll give you some context. Whereas contract law is about agreements, and more specifically, it functions from the perspective of assuming that there isn't an agreement until you can show that there is an agreement. Then there's civil procedure, which is the bureaucracy of federal courts. So it's what judges expect from you on a federal level and how you are allowed to navigate the courts. And then there's property, which should really be more defined as real estate law. It does cover more than just real estate law, but much of what you will see in that subject is regarding real estate. There is still laws regarding personal property, which is the movable, tangible things that you can pick up, like a pen. You know, pen is not real estate, obviously, everybody knows that. And also legal reading and writing is also covered in the first year. I am not going to cover that here. I'm just going to go over some cases. So, the very first case that we're going to cover is Vosberg versus Putney. And this is tort law. I'll have different videos for different subjects, so this is just going to be regarding this particular case. As you see here, by the way, I'm going to come at this from the lens of somebody that's already gone through law school, but I'm going to go over it as if this is my first time seeing these cases, with the goal of giving you some guidance of, if you're new to law school, how would you look at these cases so that we can understand what you should be outlining and how to look at these cases for the type of content that you need to look for, particularly for the end of course exams, the final exams. So I just went on the internet, as you see here, and I found this on opencasebook.org. I am going to read it. As you see here, it says Vosberg versus Putney, the schoolboy. I'll learn how to highlight properly when it says the schoolboy kicker. I vaguely remember what this is about, but let's see. I mean, it's been a long time. So whenever you're looking at these cases, you really want to start actually at the end. It is relevant to pay attention to when something occurred and where. Meaning, is it a trial court? Is it at an appeals court? Is it Supreme Court level? And for those of you in New York, Supreme Court's totally different. So I'm going on the Supreme Court definition in other states. So let's see. This one was done at the Wisconsin Supreme Court, so that gives you some context. You typically want to start at the very end of the case, where the opinion is laid out for you. Now here, let's see. Yeah, so they started with the opinion at the very end, this is good. Okay. So as you see, Justice Lite was the one that gave this opinion. And it says, several errors are assigned. Let me see, I'm going to expand this here. Only 3 of which are considered. Interesting, okay. The jury, having found that the defendant, in touching the plaintiff with his foot, did not intend to do him any harm. Counsel for the defendant maintained that the plaintiff has no cause of action. So, whenever you're looking at these cases, you always want to look at them from 3 distinct perspectives. You want to look at it from the perspective of the plaintiff, which is the person that's doing the suing, the perspective of the defendant, which is the person that's being sued, and the perspective of the judge. The plaintiff is very interested in winning the case, clearly, on behalf of their client. And in tort cases, you will learn about this later, there's something called remedies. In tort cases, the remedy, meaning the outcome that you can get from whether you win or lose a case, is typically going to be money damages. Essentially, this means you get money if you win. And plaintiff's attorneys are not always, but oftentimes, paid based on contingency, meaning that they get a percentage of how much the plaintiff individual who is doing the suing gets out of the case. I believe in California it's often 45%, so it's a pretty substantial amount. If the plaintiff wins, they get the percentage, assuming that we're talking about a contingency case, they get a percentage of that case. And if they don't win, they get nothing, which is a really big deal if you're an attorney, obviously. You're not working for free, usually. There are some cases in which attorneys do work and it's not for reasons of money. But let's not be coy here. Attorneys also have bills to pay, and making money is a big part of the reason why they are in the industry. So plaintiff's attorneys are very interested in winning for their client. The defense side is a little different. Defense attorneys are typically paid by the hour. And it's a rare occasion for them to be paid based on contingency. Or rather, it's a rare case for them to be paid based on performance. There is sometimes you can get performance bonuses, but almost always it's going to be based on an hourly basis, or as we call it, a retainer. That said, I don't want to say that defense attorneys don't care if you win or lose. They do care, but it's more because they care about their reputation than the actual specific outcome of the case. And the reality is that people want to hire lawyers with good reputations. If a lawyer has a reputation for not winning a lot of cases, or rather losing a lot of cases, people are going to think twice about hiring that lawyer. So it's a pretty big deal. And depending on the case itself will depend on what losing actually means. You can lose a case and still win the outcome that the client was expecting. And that is what defense attorneys are going to care about the most, is making sure that the client's priorities are still met, or rather that they did whatever they could ethically to get the result that the client was hoping for. And oftentimes that means, in the case of tort cases at least, reducing the amount that the defendant has to pay. It's not necessarily that they don't have to pay anything, but it could be, okay, I have to pay, but it's $100,000 instead of $1 million or more. Or I have to pay, but it doesn't set a precedent, a new law, that action B factor of this case is now illegal. And this is a really big deal, especially for clients who have a lot of skin in the game. Insurances, for example, are very interested in having very specific outcomes, because if they lose on this today, they have other cases that they also have to pay for, that they would now have to pay that extra amount if they were to lose on this particular matter. And that'll make more sense later. It's that's a whole different world. I'm not going to go too far down that rabbit hole. The judge has a totally different perspective. Judges are supposed to function as neutral, uninterested third parties. Now, I don't want to go too far down this rabbit hole, but to an extent we have to talk about the politics of politics. Judges are still people. To expect them to be 100% neutral and 100% uninterested is kind of unrealistic, if we're really being honest here. And if you really look at, for example, Supreme Court cases, this is where things get really sticky. Some of the more experienced lawyers might pitch their entire arguments to just really one judge, because some judges are so entrenched in their own personal politics that you can kind of guess which way they're going to go anyway. So if you have a very conservative justice, you know they're going to go down the conservative route. And if you have a very liberal justice, you know they're going to go down the liberal route. So really smart judges, whenever they have to, make arguments in front of a panel of judges that they already know what the outcomes are going to be, they just focus on the one that is, that wild card, because that wild card basically ends up determining what the case is what the outcome is going to be. Now, it's not supposed to be like that, but that's the reality of it. So now that we got that out of the way, the judge also has other interests, namely that they want to get the case out of the docket as fast as possible. They don't really want to mess around. They're busy people. They have, 100 other cases that they have to deal with by the end of that week. and they want to just be done with it. So if a case that's before them, they have any sort of reason to dismiss easily, meaning that they just say, you know what, this isn't really a problem. Why is this in my court? They're going to do it. They're going to try to take the easy route out. Because again, they have other cases they have to deal with. That said, the typical route that they go about doing this is by looking at precedent. The easiest way to think about precedent is to think about parenting. That's probably the easiest way, actually. It's like, if daddy said last week, if you finish your homework, you can have ice cream, right? And now you go ask daddy, can I have some ice cream? And the question is, well, did you finish your homework? And if the answer is no, they don't have to go through the process of assessing all the other circumstances. That was a prerequisite. So precedent establishes prerequisites for new cases. And precedent is built on top of each other. So if daddy says you have to finish your homework before you can have ice cream, and mommy later comes along and says, well, you also have to finish your homework before you can play outside, then that becomes a pre-established precedent. And she's just building on top of the fact that daddy said that that could be a prerequisite for something. So if homework can be used as a prerequisite to have ice cream, then later on another party, in this case mommy, can also use that same precedent as a requirement for something else. For something else. That said, she can also build her own distinct precedents, right? And I guess I should be more clear. It's more like in terms of absolutes, right? So if daddy said you can only have ice cream after you've done your homework, then that's the prerequisite, right? And if mommy says, well, you can only have ice cream if it's before 8 p.m., then that's another part of the equation for determining whether ice cream can be had or not. So if you did your homework and it's 9 p.m., you were able to complete daddy's requirement, but you weren't able to complete mommy's requirement. And you have to be able to complete both before you can have ice cream, right? But if it's 5 p.m. and you've done your homework and you go ask, it doesn't necessarily mean that you can have ice cream, but there's nothing stopping you from doing it without getting in trouble, if that makes sense. So that's how precedent typically works. All right, going back to this. Where was I? Okay. So, in this case, the defense was trying to get this case dismissed, right? The jury found the defendant in touching the plaintiff with his foot did not intend to cause him any harm. Yeah, okay, I'm in the right place. Counsel for the defendant maintained that the plaintiff has no cause of action. So this no cause of action, by the way, is the legal way of saying throw out this case because you have no legally defined reason for why it should be here. Hey judge, this plaintiff is wasting your time. That's the defense's way of saying this plaintiff is wasting your time. It's wasting everybody's time. Like there's no reason for this case to be here. Like, don't you have better things to do? Like, just get rid of it. Come on, bro. Get rid of it, right? And the defendant's motion for judgment on the special brought a verdict should have been granted, right? So this is a motion for judgment on a special verdict. That's, again, another version of trying to dismiss it, but it's later on in the trial, right? It's not something that happened at the beginning, but rather in the middle. In support of this proposition, counsel quote from so they're quoting from another case, right? 2 Grano EV 83, the rule that the intent to do harm is of the essence of the assault. So this is how lawyers do this precedent that we just talked about. They said, hey, Daddy in this other court previously said that the intent to do harm is of the essence of an assault. And in this case, we are discussing assault, which is a tort that is intentional on the basis typically of contact. This harmful and offensive contact, we'll get into that later. Such is the rule, no doubt, in the action or prosecutions for mere assaults. But this is an action to recover damages for an alleged assault and battery. So assault is separate from battery in tort law, which is different from criminal law. So there's assault and battery in torts, and there's assault and battery in criminal. And they have different requirements. So in your mind, I want you to put one in one box and put the other in the other box. And don't let them touch. Okay? In such case, the rule is correctly stated in many of the authorities cited by the counsel that the plaintiff must show either that the intent was unlawful or that the defendant is in fault. Don't you just love the way people used to talk? It's so wild, right? Like, what? If the intended act is unlawful, the intent to commit it must necessarily be unlawful. Hence, as applied to this case, if the kicking of the plaintiff by the defendant is an unlawful act, then the intent of the defendant to kick him was also unlawful. So all this intent stuff, right? Like, what are they talking about? And why do they keep talking about it? Cases like these are called common law. We inherited, is probably the easiest way to say it, we inherited law from good old Daddy Britain. And we call it common law. All these old cases, you should think about reading law like reading the Bible. Like, all of them have some sort of moral and some sort of story to them, and you're supposed to try to suss out the moral lesson, right? The guiding principle. For intentional torts, which is what's being covered here, there is a primary element of intent. Now, law has two systems of interpreting law. There is elements, and then there's factors, right? So elements, I want you to think, if this is going to get a little dark, I want you to think of elements as all the prerequisites have to be met in order for something to occur. The easiest way to think about it is, in order to be, under normal circumstances, in order to be alive, you have to have all your organs working, right? Like, if your brain doesn't work, unless you have some sort of, life support system, which we're not going to talk about that right now, unless you have some sort of life support system, you're not going to make it, right? If your heart stops working and there isn't some sort of intervention, you're not going to remain alive. In order to be alive, you need everything working. You need your heart working, you need your brain working, you need all your organs working. Factors are, I don't want to say they're nice to haves. They are a balance of things, right? Meaning, you can have all these things that you consider, but You don't have to have all of them, and not all of them are equally important. You can be missing one or two. One of them can be very much there, and another one might not be present at all. And you can have one that is just so overwhelming that you change your mind for just that one thing. The easiest way that I want you to think about factors is in the context of like dating, right? Now, some people have an elemental way of looking at dating, like, you know, they must be this, they must be that, they must have this, and if they don't have all those things, and if it's not perfectly to that criteria, it's not going to happen. But most people kind of balance things out, right? So maybe they're really, really nice, and that's really valuable to you. Or in some cases, maybe they're really attractive, right? And they may be so attractive that it just outweighs all the other things that you look at. Maybe finances are a thing, or education, or all the other things that we look at, right? Like, these are all factors. Meaning, if you're missing one of them, maybe it's not that big of a deal because you made up for it in other places, right? Or you have one thing that is just so good that that's enough. Maybe you are really, really comfortable with them because you grew up with them and you're really close with them, and that's enough. You don't care what their profession is, you don't care about their education, you don't care about whatever other factors you might look at normally for somebody that you don't know, right? So those are factors. So intent in tort law is an element. If there is no intent under an intentional tort, then it didn't happen, basically. The case fails. And so this defense attorney is saying, hey, there's no intent, so there's no assault and battery, which, you know, is actually a good way to go. If you can show that the plaintiff is saying you intentionally did this, and the defense attorney is able to show, hey, actually there was no intent, and you can't show that the person had enough intent, then the case fails. Another thing to note that is really important, and something that I think gets mixed up in modern courts, is that the plaintiff has the responsibility to show that the other side met all the requirements for the lawsuit to go through. Meaning that the defense is not required to show that there was no intent. Rather, the plaintiff is required to show that there's no intent, and the defense side, their responsibility is to cast doubt, or rather to highlight all the missing parts of the case. The way that an instructor explained to me is that building a case is like building a wall, right? Like, you do it one brick at a time. So whenever you're laying down a wall, right, what happens if you forget to put a brick? There's a big hole there, right? But you can still keep laying more bricks on top of it. Rather, you know, because walls are like staggered, a brick wall is staggered. You can put one above it, and there'll just be like this gaping hole, right? And the defense attorney's job is to grab a stick and like poke the wall and see if any bricks come out. And if a brick comes out, they have to show whoever the fact finder is, which if there's a jury, then it's the jury, and if there's no jury, it would be the judge. Their job is to poke at the wall and say, hey, there's a hole there. Like, this plaintiff was building this wall, and there's a giant gaping hole here. And if you poke enough holes, then the wall comes down, right? So I don't want you to feel too bad for plaintiff's attorneys, because it's their responsibility to build a wall. And if they build a wall irresponsibly, whose fault is that, right? So this defense attorney in this case is looking at this and saying, hey, there's a giant hole in this wall. Like, the plaintiff says that my client intentionally did something, but I don't think that the intentional part of the intentional is there. Like, take a look at this, Judge. And if the intentional part of an intentional tort that is elemental in nature is missing, then they are missing the structural support of this wall. So it's going to come down. All right. In such case, the rule is correctly stated in many of the authorities cited by counsel. The plaintiffs must show either that the intent was unlawful or the defendant is in fault. If the intended act is... Did I read this already? I think I already did. It sounds really familiar. Yeah, I did. Okay, all right, let's move on. Had the parties been upon the playgrounds of the school, engaged in the usual boyish sports, the defendant being free from malice, wantonness, or negligence. So these are all, various states of mind, right? Negligence specifically is not intentional, which is kind of actually get a little surprised that they mentioned this, but they're talking about like the intent, right? And intending no harm, because we're talking about an intentional tort, right? To the plaintiff in what he did, we should hesitate to hold the act of the defendant unlawful, or that he could be held liable in this action. Let me just take a quick note here. If you're in law school especially, this is super relevant to you. In any civil cases, meaning not criminal, make sure you say liable and not guilty or not guilty, right? If you say liable, let me read this. If you say they're guilty of a tort or they're not guilty of this tort, man, you are going to get corrected by that instructor so fast, it's not even funny. And some of them will be nicer about it than others. So just to save you some pain, liable or not liable. Liable meaning they lost the case, the defense lost the case, and the plaintiff won the case. And not liable meaning the plaintiff lost the case and the defendant was... I don't want to say they won the case. Like, defendants never win. That's another thing I should say. Defendants never win. Defendants either lose or they don't lose. And plaintiffs either win or they don't win. Just think of it like that, right? So yeah, liable or not liable in civil cases. You'll look much better if you know that. Yeah. Okay. All right. Okay. Some consideration is due to the implied license of the playgrounds. But it appears that the injury was inflicted in the school after it had been called to order by the teacher and after the regular exercises of the school had commenced. Under these circumstances, no implied license to do the act complained of existed, and such act was a violation of the order and the decorum of the school, and necessarily unlawful. Hence, we are of the opinion that, under the evidence and the verdict, the action must be sustained. Okay, they're like hiding stuff. Why are you hiding stuff from me? OpenCasebook.org. All right. Let's see. Just want to make sure this is relevant before we deep dive into it. Yeah. Okay. All right. Okay. The plaintiff testified that. The plaintiff testified as a witness in his own behalf. Okay. Yeah. That's. Well, no. Okay. Never mind. This is. Remember how I said that everybody's expected to know law? I have this little thing about it because it essentially means that every person in the U.S. is their own lawyer. And in the legal industry, we have this saying that the person who represents themselves in their own case has a fool for a client. Meaning, yeah, we're talking about lawyers specifically, but you get the idea, right? They're literally saying that even if you know a lot about law, if you don't seek another lawyer to represent you, like, that's a bad idea. So anytime I see, like, you know, somebody is representing themselves in a case, I'm like, oh man, this is not gonna end well. So I saw witnessing on his own behalf, and I had a little moment. Okay, just bear with me, I had a little moment. Alright, so I'm gonna just highlight this and make it a little easier. Oh, okay. Maybe I'll do this so that we don't get lost. As to the circumstances in the alleged injury inflicted upon him by the defendant, and also in regard to the wound he received in January near the same knee mentioned in the special verdict. The defendant claimed that such wound was a proximate cause of the injury to the plaintiff's leg, and that it produced a diseased condition of the bone, which disease was the active progress when he received the kick, and that such kick did nothing more than to change the location and perhaps somewhat hasten the process of the disease. The testimony of Dr. Bacon, what an amazing name, it's making me hungry, a witness for the plaintiff. So, okay, each side has witnesses. I probably should mention that. And witnesses can either be lay witnesses or they can be expert witnesses. And lay witnesses are people who are familiar with the specific circumstance because they have personal knowledge, and that's the whole thing that we can get into later. That means they saw what happened with their own eyes, they heard with their own ears, you know. They have relevant information of what happened. And on the other side, there's expert witnesses. Expert witnesses, like doctors, are people who have specialized knowledge in a specific area. Doctors are, well, experts in medicine because they know things about medicine, right? We have, as a nation, established that doctors have special knowledge about a subject, in this case, medicine. So doctors are allowed to testify on things even if they didn't see what happened for themselves. They can draw from a story that they're told, like, okay, this happened, you got kicked, you have this disease. They can look into the medical records and they can come up with an explanation based on their expertise as doctors, right? So that's the big difference between an expert witness and a lay witness. Where are you, Dr. Bacon? Ah, yes, a witness for the plaintiff, who was the plaintiff's attending physician. Okay. Elicited on cross-examination. Now, cross-examination is when the attorney on the other side is questioning that witness. So, this is a witness that was brought on by the plaintiff, but the defense attorney is trying to poke holes in the story of the doctor, Dr. Bacon. He's trying to poke holes in Dr. Bacon. Okay, it tends to some extent to establish such claim. Let me start over. The testimony of Dr. Bacon, a witness for the plaintiff, who was the plaintiff's attending physician, elicited in cross-examination, tends to some extent to establish such a claim. Dr. Bacon first saw the injured leg on February the 25th, and Dr. Filler, also one of the plaintiff's witnesses, so he's got more than one, first saw it on March the 8th. Dr. Filler was called as a witness after the examination of the plaintiff and Dr. Bacon. On his direct examination, he testified as follows. Now, so there's two examinations. There's direct and there's cross, right? Cross is when the opposing side is examining, so in this case the defense, and direct is whenever the same side is asking questions. So again, there's some politics on this, if you will. Doctors get paid for their testimony. And depending on which side they're representing will depend on who they are getting paid by. And that's kind of a big deal. Now there are some areas of law where the expert is paid by the plaintiff or the defendant, like no matter what. And in those cases, the experts are supposed to stay neutral. But let's be real, like, people want to get hired, right? So there is some bias there, no matter what, you can't undo it. And most experts are pretty good about trying to stay neutral because they don't want to get, I don't want to say blacklisted, but they don't want to get blacklisted from doing expert testimony if they are too biased. And law actually requires them to be neutral, but you know, they're, like I said, they're humans and they're people and they have bills to pay and they want to get a job. So especially if they're being brought on to be neutral examiners, because the way that some of these work, depending on the type of case, the expert, in some cases there's panels of experts that are round robin eliminated. I don't know how else to say it. So there'll be a list of doctors or engineers or whatever type of case it is. And the defense side might say, okay, but I don't like this expert, so let's not take this one by consideration. Let's not have this in the panel of people. And then the other side, the plaintiff side, would look at the same list, now with the one that the defense removed, and they might say, okay, well, I don't like this other person, so, we'll take this other person off the list. And they do that until like one or three remain, one or three, depending on, what type of case it is. And whoever remains ends up being the one that gets paid to go and do the work, right? So if you, as an expert, have a reputation of siding with one side too much, you're gonna get eliminated by that representation very quickly. So if you get a reputation for you always side with the plaintiff or you always side with the defendant, if they are looking for a neutral party, that expert's not going to get the job, which is kind of a big deal, right? So this is, some things that are like relevant to know. You don't need to know this in terms of like law school, but it's interesting to know about these things, particularly after you finish and start practicing stuff like that. So that's all the stuff that's going on here. Okay, on this direct examination, testified as follows. I heard the testimony of Andrew Vosberg in regard to how he received the kick on January the 20th from his plaintiff. So Andrew Vosburb is, hence the name Vosburg in the case name, is the name of the child that got kicked by his playmate and is now suing his playmate, right? And the doctor is saying, I heard this story, and this is like what I figured, right? I read the testimony of Miss Moore, and heard where he received the kick on that day. And I'm guessing, let's see. Miss Moore had already testified that she was a teacher of the school. That's what I was going to talk about next. Like, she's probably the teacher. And so the defendant standing on the aisle by his seat, kicking across the aisle, hitting the plaintiff. Okay, so she is a lay witness, right? Like, if this case was about like misconduct of teachers, then she could be an expert in that case. But this is about something medical, so she can't be an expert in a medical case. But she can be an expert, she can be an expert in teaching, and she can be a lay witness in the particular situation of like how things transpired. Being their teacher and physically being there and saying it, she's a lay witness to that. Scroll down. The following question was then propounded to Dr. Feller. After hearing the testimony and what you know of the case of the boy, seeing it on the 8th of March, what, in your opinion, was the exciting cause that produced the inflammation that you saw in the boy's leg on that day? An objection to this question was overruled, and the witness answered, the exciting cause was the injury received on that day by the kick of the shin bone. Yeah. So there was an objection, and it was overruled. Objections are either sustained or overruled. And when an objection is sustained, that question is not allowed to be asked. When it's overruled, they can go ahead and proceed. It doesn't say what the objection was on, so I can't talk about that. But yeah, so we'll move forward. But it's good for you to know, like, what's an objection? Like, you see it in movies, right? Like, objection. There's more to it than that. And by the way, in real life, you have to state, like, what are you objecting on? Like, is it on scope? Is it on hearsay? Like what is it? You can't just object for no reason, and there's actually cases on that. Like, you can't just not object for the sake of objecting to derail your opponent's case. Okay. It will be observed on the above question to Dr. Filler calls for his opinion as a medical expert, based in part upon the testimony of the plaintiff, so as to what was the proximate cause of the injury to the plaintiff's leg. The plaintiff testified to two wounds upon his leg, either of which might have been proximate cause. Okay. The proximate cause is something that's going to be discussed later in a different case. I want you to think of proximate cause as, was this something that could have been anticipated? Or was this like a butterfly effect of things, right? In this particular case, the boy kicked somebody, and the injury is being claimed as being directly from being kicked. So it's a direct cause, and direct cause is always a proximate cause. Or rather, a direct cause always qualifies as being a proximate cause. Like, it's close enough to the circumstance, right? Okay. Without taking both of these wounds into consideration, the expert could have no intelligent or reliable opinion as to which of them caused the injury complained of. Yet, in the hypothetical question propounded to him, one of these probable causes was excluded from the consideration of the witness, and he was required to give his opinion upon an imperfect and insufficient hypothesis, one of which excluded from his consideration immaterial fact, essential to an intelligent opinion. A consideration by the witness of the wound received by the plaintiff on January being thus prevented, a witness had but one fact upon which to base his opinion, to wit, the fact that the defendant kicked the plaintiff on the shin bone. Okay, so yeah, we're talking about proximate cause. We already talked about that. Based as necessarily was on that fact alone, the opinion of Dr. Filler that the kick caused the injury was inevitable. When had the proper hypothesis been submitted to him, his opinion might have been different. The answer of Dr. Filler on the hypothetical question put to him may have had, probably did have, a controlling influence with the jury, for they found that their verdict, that his opinion was correct. Okay. So they agreed with the doctor, as a matter of fact. Right. So there's matters of law and there's matters of fact. Matters of law are done by the judge. Matters of fact, when there's a jury present, are done by the jury. They are the finders of fact. So we'll get into that much later. Surely there can be no rule of evidence which will tolerate a hypothetical question to an expert, calling for his opinion in a matter vital to the case, which excludes from his consideration facts already proved by the witness upon those upon whose testimony such hypothetical question is based. When a consideration of such facts by the expert is absolutely essential to enable him to form an intelligent opinion concerning such matter. The objection to the question put to Dr. Filler should have been sustained. Okay, so they're actually talking about the objection, right? Like they're saying it was overruled, meaning that they were able to proceed with the objection, but that was incorrect, like it should have been sustained. Meaning that this doctor should not have been allowed to talk about this, or the question should not have been allowed to have been posed in the way that it was. And objections are a whole different thing, we're not going to get into that. But the error in permitting the witness to answer the question is material and necessarily fatal to the judgment. Okay, so this is again, it's a wrinkle in the case, and it's really relevant for somebody that's like me looking at this backwards. Meaning, I've already passed the bar, already gone through law school, and now we're looking at objections, and we're looking at what should be sustained and what should not. Now, material is, when you hear material in anything law, I want you to think, is this important? If it's important, it's material. If it's not important, meaning it's not going to change the outcome of the case, then it is immaterial. Okay, not material, immaterial. And they talked about it here, like it's necessarily fatal to the judgment, right? So if what they're saying in this particular, like the error permitting the witness to, that, they're saying the very fact that this doctor was, or rather that the attorney was able to ask this question and the doctor was able to answer it, or required to answer it, is of such high importance that on its own it can sway the opinion of the jury and determine who wins and who loses. Or, who wins and who loses. So that's, not too important in understanding this case as law school would expect you to do it, because you're going to have other cases that talk about material and immaterial. But it's interesting to see. Right? Okay, now section 3. Certain questions were proposed on behalf of the defendant to be submitted to the jury, founded upon the theory that only such damages should be recovered as the defendant might reasonably be supposed to have contemplated as likely to the result of his kicking the plaintiff. The court refused to submit such questions to the jury. The ruling was correct. The rule of damages and actions for torts was held in Brown versus CM and St. PR Co. Okay, those are all acronyms. Anyway, there would be the wrongdoer is liable for all the injuries resulting directly from the wrongful act, whether they could or could not have foreseen him. Whether they could or could not have been foreseen by him. Chief Justice and the writer for, and the writer for this opinion dissented from the judgment. Okay, so this is actually like, this is kind of a strange little thing to look at, because when you're in law school, like I said, you're expected to know all three major perspectives, right? And law ultimately looks at who won the case and what the opinion, the major opinion was. But dissenting opinions, meaning the perspective that was not the reasoning necessarily for why it was or was not a winning case, give you kind of a cheat code level of perspective of what was this other judge looking at that said, this case should have gone the other way. Or this case was correct, but not for the reasons that this other judge is saying. Like they can disagree and they can agree as to the outcome and disagree as to the reasoning. And these things are important. The Chief Justice, in the writer of this opinion, dissented from the judgment in that case, chiefly because we are of the opinion that the complaint stated a cause of action ex. These are old terms. I gotta look these up again. Ex contratio and not ex delicto, and hence that a different rule of the damages, the rule here contended for, was applicable. We did not question that the rule in actions for the tort was correctly stated. Okay, interesting. Yeah, okay. So this is a dissenting opinion. We did not question that the rule in action for the tort was correctly stated. That the case rules in this questions of on the question of damages. So they're not saying that it should have gone the other way, but that the amount that was awarded should have been different. The remaining errors assigned are upon the rulings of the court on objections to testimony. These rulings are not very likely to be repeated on another trial and are not sufficient or that are not of sufficient importance to require review of them on this appeal. Okay, by the court, the judgment of the circuit court was reversed and the cause will be remanded for a new trial. So they said that this is interesting, like whenever you look at these, you need to keep track of like what happened, right? And what the outcome was. So this case, the original, they said it fails. Meaning that the case didn't go through. But in what we're looking at now, they looked at it and they said, you know what? This was wrong. This was what the other court looked at was incorrect. And sometimes a court like a Supreme Court will just look at the whole thing and they'll make a determination for themselves. And in other cases, they'll look at it and they'll say, okay, you got the law part wrong. You didn't get the facts wrong necessarily, but you got the law part wrong. So we're going to correct the law part and we're going to send it back to the original judge that made the decision or that finding, and we're going to make them correct themselves, right? Which that do you want to be a lawyer that has to go back to a judge that you just proved them wrong? You gotta think about that too. Like, it's not necessarily a pretty circumstance to be in, because people can be pretty prideful, and maybe they're not gonna like that. But that's the job, right? So some politics to it, right? So whenever you're looking at a case, you always want to start with the opinion and then kind of work your way backwards. So the opinion was the judgment was reversed, right? And they found it was all in a matter of intent. Or like the old case, they said that the old finding was incorrect. So now let's go back and look at what was removed, right? Once you know what the outcome, you have to try to kind of reverse engineer some of these. And I know right now these things don't really make a whole lot of sense. It will make more sense as you progress. So for now, I ask that you just bear with me. Okay. Now let's look at the facts, right? A kick upon the leg given by one pupil to another in the schoolroom, and while school was in session, was an unlawful act, and an action for assault and battery may be maintained therefore, although there was no intent to do harm. The wrongdoer in such case is liable for all injuries resulting directly from the wrongful act. Let's see, is this a summary? Okay. I'm not too familiar with open case bugs, so we'll see how this goes. Although there was no intent to do harm. Okay. 2. The wrongdoer in such a case is liable for all injuries resulting directly from a wrongful act, whether they could or could not have foreseen by him, could or could not have been foreseen by him. It is error to permit an expert witness to answer a hypothetical question which calls for his opinion in a matter vital to the case, but excludes from his consideration facts already proven by the witness upon which testimony such a hypothetical question is based, and when a consideration of such facts is essential to the formation of an intelligent opinion concerning the matter. Okay, so this is now being appealed from the circuit court. Okay, for the, I don't know how to pronounce that, Waukesha County. We're gonna go with Waukesha. The action was brought to recover damages for the assault and battery alleged to have been committed by the defendant upon the plaintiff on February the 20th, 1889. Okay, so this case is old, right? This is, by the way, part of the reason why I even decided to start making videos concerning law, because the way we teach law is so old. Like, the Socratic method has been around for forever, and somehow we haven't updated it. We haven't looked at it and said, you know what, like, yeah, this worked 200 years ago, but we have different tools now. We have different ways of doing things. Like, maybe we should make an update. I'm just saying, maybe we should do that. Maybe we should do things a little different. So I figure, you know, the Socratic method can be taught, but sometimes you just have to see it. You just have to see what a lawyer's thinking, and they'll give you some insight. Like, I remember asking an instructor, like, okay, well, what's your thought on this? You know, what, I asked them, okay, let me start here. I did not come from a family of lawyers. So I didn't know what I was getting myself into when I went to law school. I was clueless. I mean, I was trying, you know, but if you don't have somebody to ask questions to, like, it's a really confusing place, frankly. And so I asked this instructor, because I was trying to figure out how to do these essays. You know, law school grades, almost all of them, depending on the school, but almost all the schools, the entire grade is based on the final exam. So if you do well on the final exam, you're golden. If you don't do well on the final exam, oh man. And unfortunately, it doesn't really matter so much how well you do, so much as how well you do compared to everybody else. Law school is a race. You're competing against other people, and somebody's always going to be first and someone's always going to be last. So, yeah, you're not competing against the instructor, you're competing against your classmates, which is an interesting place to be, because you're trying to make friends too. Like, you want to build connections, you want to be friendly with people, but they're also your competition, which is a wild place. And you'll kind of see that in practice too. Like, you want to be cordial with, you know, opposing counsel, which is the lawyer on the other side. And sometimes you might need a favor from them, and sometimes they might need a favor from you. And most lawyers will try to be accommodating if they can be, and it doesn't affect their client too much. Like, maybe, you know, somebody missed a deadline, or you know they needed an extension or something like that. You don't want to make too many enemies, and at the same time, they are your competition. And if they win the case, you might lose your case, or rather, especially if you're defense, your client is not going to get the outcome that they want or need. Kind of a problem. So it's a totally different battlefield from what you would see in like a 4-year program, a bachelor's, or you know, other methods of schooling. So I was asking this instructor, okay, but like, how would you write these essays, right? And by the way, these essays are timed. So you go to, you know, a testing room, and there's just keyboards clacking away on a made-up scenario. So you learn all the lessons all these parables. You learn the lessons from all the little stories like this one, and you put them all together. You put them all into practice on this like made up scenario that the instructor came up with at some point, maybe over the weekend, I don't know. And your job is to try to put them all into use, right? And I remember asking this instructor, like, how would you write it? And they said, well, the way that I write it isn't the way that you would write it. And they didn't really tell me much. It was just like, okay, cool, but how am I supposed to write this then? Like, if you don't tell me what you're expecting on the exam, how do I know like what I'm supposed to do? And that's a really big, I don't want to call it a flaw, but it's one of those really big aggravations of law school, because they all play this game of like hiding the ball. That's what they're, literally what they call it, like it's a game of hide the ball. And to an extent, it's how well can you get along with people who can give you intel, intelligence, meaning information on things I don't want to say you're not supposed to know, but how can you uncover this like secret knowledge? And if you come from a background where you're familiar with that, like you got to get your information from them, right? So if your parents are lawyers, you can just ask them, like, hey, how do I look at this case? I'm like, what am I supposed to be thinking? And the reality is I didn't have that. And it seems this instructor didn't want to give it to me either. So you're at a pretty substantial disadvantage if you don't have that. Which is part of the reason why I'm, going through all this too. Because this is, I think, what I wish somebody had done for me. When I was going through law school, like, I remember trying to figure this stuff out, and you just go on Google and you're like, well, preparing for law school, like, what do I like? What do you don't even know what to Google, let alone finding it. And maybe you come across a channel that does like summaries, or they do these little videos. They don't really teach you what you're supposed to be thinking. They don't really teach you how you're supposed to go about this. They don't teach you what's important and what's not. And law school doesn't really I don't want to say they don't do a good job at it. It's more like they intentionally make it where it is difficult to find it. And I don't know how much of that is prestige. Maybe there's like a very specific reason why they do it that way. There is a lot of discourse, a lot of people that are saying, this is just protectionist. We're just doing it to keep old money and old money. I don't know which is right or wrong. All I know is that there was, especially a point when I started law school, my first year, where I really just needed somebody to give me some guidance, and I didn't really have that. So, I don't know. Maybe this is my way of paying it forward, right? Like, what I wish somebody did for me. So here it is. Okay. The action was brought to recover damages for an assault and battery, alleged to have been committed by the defendant upon plaintiff on February the 20th, 1989. So again, this is an old case, and like nothing's changed, right? Which is kind of like what I was getting into. Like, law schools are really, really expensive, and they're really hard to get into. And you're expected to function as a member of society as if you had gone to law school. But the way that we've been teaching them hasn't really changed in like 100 years or more, in some cases. And we're just repeating the exact same cycle over and over and over again. Like, and to me, it's like, why can't we just record it? Like, what? Why are we doing the same work over and over? Like, this is dumb. We should just do the work once, do it right, and let society reap the benefits from it. So that's kind of why I'm doing this long form. Like, what am I thinking here? What am I doing there? What am I saying? Because this is like what you're supposed to do, kind of. but in a newer form. So we'll see how it works. Maybe it'll work for some people, maybe it won't. Maybe it'll give you some insights. Maybe it'll allow you to ask different questions. Maybe not better questions, but different questions, right? So we'll see. We'll see. The answer is a general denial. At the date of the alleged assault, the plaintiff was a little more than 14 years of age, and the defendant a little less than 12 years of age. Okay, so they're young. They're not like preschoolers, but they're teens, right? Okay, cool. The injury complained was caused by a kick inflicted by the defendant upon the leg of the plaintiff, a little below the knee. The transaction occurred in a schoolroom in, I know I'm going to butcher it, Waukesha? During school hours, during the parties being pupils in the school. A former trial, not formal, I guess that is formal also, but it's former and formal. Trial of the cause resulted in a verdict and judgment for the plaintiff for $2,800. Okay, so you remember that reverse that happened earlier? This is like where it becomes really, really relevant. So the former court looked at this situation and they said, okay, yeah, there was intent and we are going to give you $2,800. Now this is in 1889, right? Like, how much was $2,800 worth in 1889? I don't know. And I don't trust these inflation calculators. I don't. Am I weird for that? And in part, I don't trust them because like the standard of living is different. So, okay, fine, $2,800 back then, maybe like $100,000 today. I don't know. I don't know what the math is. But what did it buy you back then? That's what I want to know. Like, could you buy a house with $2,800 in 1889? I don't know. Big deal, right? Like the inflation numbers to me, they don't make sense anymore because let's assume for a second, right? Like, let's assume for a second that $2,800 is $100,000 today. Cool, but where in the U.S. can you buy a new house for $100,000? Oh no. Whereas in this imaginary world that I'm living in 1889, maybe somebody could have purchased a house for $100,000, the equivalent thereof, right? Which is $2,800 in this case. So I don't. This is a total tangent here, but I don't trust inflation calculators because they don't account for buying power, and I feel like that's far more relevant than like a conversion of, okay, inflation increased by this amount, especially in today's world where like numbers just don't make sense anymore. I mean, have you looked at the real estate market? Like, math ain't mathing on that one. It just isn't. Anyway, let's get back to this. The defendant appealed from such judgment to this court, and the same was reversed for error, and a new trial was awarded. Okay, yeah, we already know that. The case has again been tried in circuit court, and the trial resulted in a verdict for the plaintiff for $2,500. Okay, so again, this is what got reversed, by the way, the opinion of the circuit court. If you remember, like down below in the opinion, it said that they reversed it. So the trial court said $2,800, and then it got appealed, right? And then it went down to $2,500. So they're like, yeah, we still think that there was intent, but we're not going to do that much money. Yeah, okay. And then later on, the Supreme Court said, yeah, we don't find any intent here. So, yeah. On the last trial, the jury found a special verdict as follows. Had the plaintiff, during the month of January 1889, received an injury just above the knee, which became inflamed and produced pus? Answer, yes. Had such an injury on the 20th of February 1889 nearly healed to the point of the injury? Yes. Was the plaintiff, before said 20th of February, lame? I guess this kid was lame. Cool. As a result of such injury? No. I don't know what being lame is for that time frame. Look, I'm curious. What do you think? I don't know if that's relevant right now, but I want to know. Had the tibia, which is a body part, by the way, specifically on the leg, in the plaintiff's right leg become inflamed, okay, yeah, that's what I actually said it, or diseased to some extent before he received the blow or kick from the defendant? No. Was the exciting cause of the injury to the plaintiff's leg? What? Oh, sorry. What was the exciting cause of injury to the plaintiff? So now we're talking about proximate cause and direct cause, right? Like that's the kick. So they're asking, like, okay, what made all this happen? And why did this happen? Why are we here? Okay, because of the kick, right? Did the defendant, in touching with his foot, intend to do him any harm? No. Who do they ask this question to? I want to know. Okay. Like, was it the doctor that they asked this question to? Like, or was it that the... Hold on, let's go back here. Last trial jury found a special verdict as follows. Was it the jury that was the trial of fact? Maybe that's how they found out. Right? Like it was the jury. We're gonna blame it on the jury. Okay. What sum do you assess the damages of the plaintiff to 24 months? Okay, so yeah, it is. There actually were. The jury was the trier of fact, and they decided that the exciting cause was the leg, which was the kick, right? Like so, this is interesting actually. Like looking back on this, because the jury themselves said, we don't find any intent. And this is an intentional tort. This is an intentional tort, and we, in reviewing the testimony of the witnesses and reviewing the testimony of the plaintiff and the testimony of the defendant, and when we listen to everybody's story, we have come to the determination that we feel that there was no intent to cause harm. And so at this time, if I remember, okay, yeah, we're gonna move to that later. But at the time, we're talking about like unlawful, right? Unlawful and necessarily, okay, it was an unlawful act, and the intention of the defendant to cause them was also unlawful. Where was the specific word? The intent to do harm is the essence of assault. Like that's what they're quoting, right? The intent. Here we go. An intent to do harm is the essence of an assault. And here, the defendant, in touching the plaintiff with his foot, intend to do him harm, and the answer was no. So if the essence of an assault claim, actually later there'll be battery. If the essence of this type of claim, this like you did this to me and now you must pay, if the essence, that very core element was the intent to do harm, what did I say? The essence of an assault, the intent to do harm, and then the jury says, hey, we find that there was no intent to do harm, then that means the whole case just failed. Which is what the Supreme Court ended up coming up with. So, the Supreme Court in this case is not looking at, they're not looking at if the person intended to do harm. That's not something they're looking at because they weren't asked to look at that. Whoever made the writ, whoever requested the Supreme Court to look at this case, they said, hey, Supreme Court, we don't need you to look at the whole case. We just want you to look at this like one thing. Just look at this one piece of law, right? And really, like, maybe they said it earlier. I mean, that's not really like what's being answered, but they were really being asked, like, if the law says that intent to do harm is the essence of this type of claim, and the jury comes back and says, hey, we didn't find any intent to do harm, should they have gotten any money? And they found that the answer was no. And that's essentially what this case is about, right? So then it says the defendant moved for, okay, whatever. The defendant moved for judgment in his favor on the verdict, and also for a new trial. The plaintiff moved for judgment on the verdict in his favor. The motions of the defendant were overruled, and that of the plaintiff was granted. Thereupon, the judgment for the plaintiff, $2,500, and the cost of the suit was duly entered. And defendant. So that was the result of the old trial, right? Before we came in and looked at this one, which is the new, improved and new and improved version of the trial, right? Version 2.0, right? Like that's the way to think about it. It's version 2.0 of that old version trial, right? Okay. Let's look at this. Yeah. Okay. Let's see what it says here. T.W. Hythe, attorney, and Jacob J.V. Quarles of counsel for the appellant contended, inter alia, that if the testimony was such to establish a reasonable inference that the alleged kick was in any way the cause of the plaintiff's misfortune, it may likewise be reasonably assumed that among boys it is an unavoidable accident, or at most an excusable one. Okay. Harvey versus Dunlap, Hill and Malone, Daniel. Yeah, okay. So they're just like quoting all the cases, the reasoning, right? Let's see. And the rule governing liability as well as damages should be the same as cases of negligence. Yeah, okay. We're not talking about negligence here, so we're not going to cover that. Okay, this is all negligence stuff, so we're not gonna cover that. So I hope this, like, I know, being the first case, this is probably one of the first cases, if not the first case that you see in tort law, and we like to do things the old-fashioned way in the legal industry. So this is all like super old. Written and said in the old way, and nobody talks like that anymore. So none of this stuff like naturally makes sense. And if you're feeling a little bit like, what did I just go through and what did I just see? Like, know that you are not alone. Like, you saw the way I was reading this, right? I was like, what? What did they say? Huh? Did I say the right word here? Like, that's normal. Like, really. So if you're in law school and you're going through these cases and you're just like, man, I have a headache. I don't know if this is right for me. I don't know if I belong in law school. Know that you are not alone. And even after you're done with law school, and even after you've had years of practice, like, you're still going to be revisiting some of these old cases. Like, it's never over. Like, so just have some patience with yourself. Really, forgive yourself, and just love yourself through the process. Law school can be challenging, but it can also be hugely rewarding. It really can be. If you're not in law school and you're seeing this and you're going, huh, that was a little wild, but you know what? If I can survive day one, maybe I can do law school. Like, you know what? You should go and you should take the exam. I'm so serious. Know that the preparation for it can take quite a while, and it most definitely will pay dividends if you get a good score. I don't know which schools require the LSAT anymore. The law school admissions, what was it? Law school admissions, something test. Anyway, it's the entrance exam for lawyers, for law school. I believe Harvard allows the GRE as a replacement for the LSAT now. I don't remember. Like, all law schools, as far as I know, still take the LSAT, but not all of them require you to take the LSAT in order for you to apply. So take a look at it. You know, see if there's a school that you're interested in that, you know, that maybe you've already taken the exam you can apply for. If you have no interest in law school whatsoever and you're watching this and you're going, that was a total huge waste of time, I don't blame you. Let me start there. I don't blame you, because man, the way some of this stuff is written is just like, okay, why should I care? Like, really? And in the beginning, none of this stuff makes any sense. But as you build on top, it's kind of like having a Lego set, you know, where if you only have one block and you just look at the one block, like, you just like, okay, whatever, what am I supposed to do with this thing? But then you look at the box and you see this like glorious design, and you realize that each Lego piece is just one part of that Lego design. And if you learn how to put all the other pieces together, then you can learn how to put this design together. So it goes very, very far. So this is the first video and the first case that we'll be touching on. So stay tuned for more, I guess. We'll cover the other subjects later, but you know, let me know what worked for you and what didn't, and we'll see if we can make some adjustments as we go. All right.